Good evening. I'm Carolyn Schoenberger, and on behalf of the Chicago Legal Clinic, I'd like to welcome you to Immigrant Issues. And with me tonight is Drew Curle, who is the supervisory attorney of our Austin office, and is going to talk about expungements and sealing of records. The law has changed, and it will help a lot of people. But first, I want to talk a little bit about the Chicago Legal Clinic. The Chicago Legal Clinic was founded in 1982 by two brand new lawyers, and the reason that it was founded was because there was no low-cost or free legal service agency in the south of Chicago. At one point, it was a thriving community, but when they started closing the steel mills, people lost their jobs, people couldn't go out to eat. So not only were people having problems, but the businesses started having problems. And if people had legal problems, there was no way to get assistance. So the Chicago Legal Clinic was founded in one room with the idea that, they would help people who had low incomes with a multitude of civil problems. Fast forward. Today, in 2018, soon to be 2019, there are 4 neighborhood offices: South Chicago, Pilsen, where I work, Austin, where Drew works, downtown, and there are several free clinics associated with the courthouse, one dealing with foreclosures and then child support, plus there is an advice and referral clinic at Harold Washington College where I teach. So if you have a problem, it could be domestic violence, immigration, if you want your records sealed, your criminal records sealed or expunged. If you have a problem, you want to sell property, or if you want to buy property, Social Security, disability. If you have any civil legal problem like that, please call the number on the back of the screen, 773-731-1762, 773-731-1762. Please call Monday through Friday between 9 and 5 p.m. So I'm now going to talk a little bit in Spanish. Buenas tardes, me llamo Carolina Schoenberger y yo quiero decirle un poco de la Clínica Legal de Chicago. Yo soy abogada con la Clínica Legal de Chicago. La Clínica Legal de Chicago fue establecida en 1982 por 2 nuevos abogados. Antes de 1980, había muchas acerías en el sur de Chicago, pero se cerraron a las acerías y por esto la gente perdieron su trabajo y negocios en el sur de Chicago sufrieron por la falta de clientes. En este barrio no había ninguna oficina legal ofreciendo ayuda legal a bajo costo. Entonces los 2 abogados establecieron la Clínica Legal de Chicago en un solo cuarto. Actualmente hay 4 oficinas de la clínica, uno en el sur de Chicago, Pilsen, donde yo trabajo, Austin, donde Drew trabaja, y en el centro también. También hay 2 oficinas que da aviso gratis en las cortes, uno con foreclosure, el otro con mantenimiento de los niños. Y hay una oficina en Harold Washington College, donde soy profesora, que da asistencia legal, aviso y a los estudiantes. Entonces, si tiene un problema con inmigración, un problema con si quiere limpiar sus expedientes, violencia doméstica, bienes raíces, también seguro social con gente incapacitado, testamentos, usted puede llamar el número central de la clínica entre las horas de 9 hasta las 5 de la tarde. El número es 773-731-1762. 773-731-1762. Y si tiene unas preguntas, llámanos. El número es 312-738-1060. Quiero decir algo más. Si usted es inmigrante o si conoce gente que son inmigrantes, hay ayuda y no pierda esperanza. hay ayuda legal, no solamente por medio de la Clínica Legal de Chicago, pero hay ayuda. Y no tiene miedo de salir de su casa, porque ellos ganan si tienen miedo de salir de su casa. Entonces voy a hablar con inglés. Si tiene preguntas, llámenos por favor, sea a la clínica o durante este programa. So I was saying in Spanish that it's important if you are an immigrant or know people who are immigrants. It's hard not to be afraid, but you have to live life. There is help out there, not only through the Chicago Legal Clinic, but through other organizations. It's very important, otherwise they win. So very important to live your life. So having said that, again, I want to welcome Drew Curle from our Austin office. Welcome.
Thank you for having me.
And Drew, if you could tell us a little bit about this new, well, it's a relatively new law dealing with expungement of criminal records and sealing of records.
Yes, so Illinois, it's just for the state of Illinois, but Illinois passed and the governor signed a new sealing bill into law in late August of 2017, so it's just a little bit over a year old now, which greatly expanded the range of cases that can be sealed. Historically speaking, sealing was only available for a small subset of cases, so only certain misdemeanors and a very small handful of felony convictions were eligible to be sealed. Now, instead of that, they've carved out just 4 exceptions of conviction types that cannot be sealed, with everything else being eligible.
What are the 4 exceptions?
The 4 exceptions that still can't be sealed are convictions for domestic battery and related crimes, DUIs and related crimes, sexual assaults and related crimes, and then finally animal cruelty type cases.
So could murder?
Murder theoretically could be sealed, and that's actually a good segue because just because a case is eligible to be sealed doesn't mean it has to be sealed. It's within the judge's discretion at that point to grant it or not. And that's important to remember because many people now have a criminal record that can be sealed, but that doesn't mean that the judge is going to do it.
So, assuming that someone has either, I guess what I should ask first, what is the difference between expungement and sealing?
That's a good question too. So expungement essentially means the record is destroyed wholesale. Law enforcement is supposed to get rid of their copies. The clerk of court gets rid of their copies. And essentially no one has access to it. A sealed record, by contrast, means that the police agency, so the arresting agency, which in Chicago would be like Chicago Police, but it could be whatever local agency, and then the Illinois State Police seal their records from public view, but law enforcement itself can still see it. So if you were to get arrested again, they would see those, or if you apply to work for law enforcement, they would see those.
So we know that immigration, first of all, considers supervision, which is not considered to be a conviction in Illinois. Supervision, according to the Immigration Service, is a conviction. And even if you seal the record or expunge it, they can see it.
That's correct, and that actually is another important area to talk about, which is for immigration purposes, sealing your record will not have any effect to help you, and in fact expunging it won't either, because you're supposed to report all of your arrests and convictions to immigration authorities. And so an important thing to keep in mind when you do this is that first of all they're going to see it, and then second, before you go ahead with an expungement or sealing, you want to make sure you have duplicate records for your own purposes of any arrests and other things like that. Because obviously once it's expunged or sealed, you're not going to be able to get those again, or at least not very easily, because those records have been sealed from public view.
We actually, in the Pilsen office, we have an attorney who gets a fair amount of cases where he has to go to court, unseal a record, get the documents, get them certified, and then seal it again.
Exactly, and so that is possible, but obviously it's more work, and it's the kind of work that you often need to get an attorney to specifically help you do. So you can avoid that and save yourself some time and hassle down the road just by keeping those records in the first place, so that way you don't have to unseal them to get access to them.
And save your money.
Exactly.
So it's a great idea, but so why should someone seal or try to expunge their records?
So in general, people want to do it for employment reasons and housing reasons. And so that's an important thing to keep in mind is that, when you get a record sealed or expunged, it doesn't matter so much which of those it is for most private background checks. So for instance, a sealed record, law enforcement still sees it, but if you're just trying to work for a non-law enforcement agency, if you're trying to just get a job, a sealed record or an expunged record, either way, it's not going to be available on a background check. and so you'll be able to pass it. Same thing with housing. A lot of times a background check will be done as part of an apartment application or something, or a loan application, and that can be important to be able to pass that too.
So expungement, again, means it doesn't exist, and sealing means other people can't see it. How do you start a case?
Well, you can contact us at the number behind us, and we will, one of our attorneys, either myself or someone else at the agency who does expungements and sealings, will be in touch with you. Essentially, for our process, the first thing you want to get is a copy of your Chicago Police rap sheet. And that's important for two reasons. First of all, it's required for any new filing of an expungement or sealing case, so you just have to get it. And then second, that also lets us see what your background is so we can tell you what kind of relief you're eligible for. And you can get that from Chicago Police Headquarters, which is 3510 South Michigan. You go there in person with yourself with $16 and a copy of your photo ID, and they will process it for you and then have you come back and pick it up in the afternoon. You get that and send that to us, and we'll get to work on your case. One other thing I will note is that there is a help desk inside the Daly Center here in Chicago where there's attorneys at a different legal aid called CGLA. They can help you prepare your expungement and sealing petition. They won't actually represent you in court, although there may be another attorney either from my agency or a CGLA that could be there. But they will help you prepare the paperwork and otherwise get ready to file your case.
Do you have to go to 26th Street, or can you do that in the Daly Center?
You can file your case in the Daly Center, but if you have an objection in your case, that's going to be heard at 26th Street, which is the criminal courthouse in Chicago.
So when you go to so you can go to court at 26th Street, and what happens when I assume you get to a courtroom, and what happens?
Yeah, so I'll kind of walk through the process. So if you file through us, or if you file on your own or with assistance from that help desk in the Daly Center, no matter which way you file in the Daly Center, the next step that's going to happen is you got to wait to see if there's an objection in your case. And this is actually an area where procedures have changed in the last year. We're actually more like 6 months. It used to be that when you filed, you got a court date assigned right then and there, and you showed up on that court date, and then that's when you found out if there was an objection. Now, what the state's attorney is doing is they mail objections to people within 60 days of the date you file.
Wow.
And only if there's an objection do you get a court date assigned. So if there's no objection, you don't even have to go to court, you just get an order in the mail.
Sounds like it's a lot more efficient.
That is the idea, and right now we're transitioning between the two systems, so it's a little bit chaotic, but I would say by probably early spring of next year, it should be 100% under the new system where people don't have to go to court unless they actually need to be there.
So what kind of cases do they object to?
So it's within the state's attorney's discretion to decide what they want to object. I would say two main baskets of things. One, they will file statutory objections, which are when people apply for relief they're not eligible for.
Like domestic violence or
exactly.
Cruelty to animals.
One of those ones, and you're trying to get it sealed and you can't. Or you're trying to get a conviction expunged instead of sealed, and you got to switch those ones. Or the other one that you see that's statutory is a drug-related case that requires a drug test to be included in the filing, and it's not there. So that's one area, is just an issue where there's some sort of statutory issue you got to fix to get any relief. The other is what they call public policy, and that is their kind of discretionary thing where they're essentially saying that they believe the people's right to know about this case outweighs the petitioner's right to get it sealed or expunged.
So what falls in, is it a case-by-case thing, or are there categories?
It's case by case, but I would say in general the areas that they're most concerned about are kind of what you'd expect. So more serious cases, crimes of violence, or sexual crimes or crimes against children, and then also more recent cases. So if it's only been a little bit of time since the last arrest, that's more likely to get an objection as compared to something where it's been, potentially decades ago.
So where do you go for the drug test?
You can go anywhere you want. The place we recommend most often is Task Labs, which has a couple of different addresses here in Chicago. I believe one on Roosevelt Road and the other is on Clinton. We recommend it just because they do a lot of these cases and it's only $25. But if you have another place that you do drug tests at, for instance, through your employer, if they require regular drug screens, you can submit that as long as the test is within 30 days of the date of filing.
So, so someone gets their drug test, they pay $16 to get their documents from the police. What are the filing fees?
So that is a good question too. For the next, what day is today? It is the 19th. So for the next 12 days, if you file an expungement case here in Chicago, you can get a free filing for that expungement. There is a pilot program being run just for the year of 2018 in the clerk's office, where any non-conviction expungement, so not including supervisions, is a free filing. So you kind of want to get that in soon because you can save some money, because otherwise the filing fee is $120 to file plus mailing fees from the clerk's office plus $9 per certified disposition that you need for each case.
So it'd be about, what, $150?
I'd say that's a good estimate, and if you have a lot of cases, it could go up a little bit from there.
So it's per case?
Per case.
That's so right now, I hope everyone hears and spreads the word. If you are thinking of cleaning your records, which is what my clients would say, expunging or sealing, now is the time.
Now is the time, because for the next 12 days, you'll be able to file that for free and save yourself potentially about $150.
I should also mention that there's another thing that is happening. You used to be able to deduct alimony payments from your taxes, and that ends at the end of the year.
That's correct. So the other hat that I wear as an attorney is I do family law cases as well. And because of the federal tax bill that passed this year, one of the things that happened as part of that is people who pay maintenance, which used to be called alimony, no longer can deduct that from their income for tax purposes. It used to be that if you paid, say, $5,000 to your ex-spouse, that $5,000 would be counted as their income and not yours. That is no longer the case, or won't be starting in 2019. Important to know is old judgments won't be affected by this, so if you already are doing maintenance, you'll be able to keep doing it the way you did before. You won't have a new tax liability. But if you're thinking about filing a divorce or you're in the middle of a case, again, it could be advantageous to finish it before the end of the year, because starting next year, you're going to be under that new thing and your tax bill could be quite a bit higher.
No, I think it's important. I knew about the taxes. I didn't know about the free expungement. I think that's critically important, and I think that employers look.
They do, and it's become one of the more common features of a lot of job applications now is to not only ask if you've ever been convicted of a crime, but to actually do a background check with that as well. And so the expungement and sealing would let you answer no on that conviction question, and also would be able to make it so that if they do the background check, it'll come up empty, and that can be the difference between getting a job and not.
Well, for every immigration case, they of course do background checks, and that's why it's important if you're going to seal your record to make sure you have copies, because there are certain people that I would say, based on your conviction, do not try to file an application to become a citizen, because you'll end up probably in removal proceedings, which is also known as deportation proceedings. So it's important for many reasons to make sure that you keep copies. I actually had a case earlier this year where someone's records became confused, and the Immigration Service was convinced that my client had an outstanding misdemeanor warrant, and he didn't. And eventually he had to go to the state and get a judge to basically say,
quash the warrant, or say
yes,
it's been quashed.
that it's not the right person, but somehow his name ended up on a warrant, and we ended up having really a terrible time on the citizenship because of that. So you really have to be careful and know about it. It's interesting how the records and the arrests really touch every part of life, from employment to
housing to if you're looking to get legal status in the country. I mean, it can be a lot of stuff.
So if I called the clinic and someone called and you'd help people fill out the papers and then go to court, and you're only going to go to court if there's an objection, and it's up to the judge, correct?
Correct.
Are there certain areas where you would advise people you probably don't want to do this?
There are. So one thing that we often advise people is to wait a little bit longer if it's been very recent since your last conviction.
What's very recent?
Well, so that's a good question. So there's a statutory waiting period of 3 years from the end of the sentence to get conviction sealed. So that's one thing where if it's within that 3-year window, we just tell people you got to wait until that's over, because even if you filed for the relief, the judge would have to deny it because you're not eligible yet. If it's a supervision, by the way, it's only 2 years. And if it's a expungement for a dismissal or a finding of not guilty, there's no waiting period on that. But an important thing to keep in mind is that even if you're technically statutorily eligible, often the judge is more likely to grant it if it's been longer since that last offense. And so especially in the advent of a conviction as opposed to just a dismissal, we'll tell people, you should probably wait a year or 2 years longer than is absolutely required, just because you're more likely to be granted then. And that depends. So that's a case-by-case thing. So it depends on the seriousness of the case, if you have other cases in your background, that kind of thing. Because if it's something where you only have one conviction ever, the judge may be more likely to say, okay, we'll grant this anyway. But if it's a pattern where there's been several cases, he might say, we need to go a little bit longer to see that, this stuff is really in your past and not going to happen again.
I imagine if there are a series of convictions that the state's attorney's office might not agree to go ahead.
And so that's when you get more likely to get an objection from them and have to have a hearing. Whereas if it's been a while since the last case, they'll tend to not object then, and then you don't even have to go to court, which is, again, one of the advantages potentially to waiting, is that you can avoid that court appearance where you might end up getting denied.
At the court hearing, do you put evidence in, or do you have testimony?
It depends how the judge wants to do it, but yes, often they'll have the client testify as part of it, and then typically he or she, it depends on which judge you get, will like to see some other evidence of what's going on in your life. So common things to have are character reference letters, a letter from an employer, letters from organizations you volunteer for, or from churches or other places of worship that you might be a member of. And then also, sometimes they'll want character witnesses on your behalf, which could be family members or anyone who's known you for a long time, but also, for instance, an AA or NA sponsor, if there's been a drug problem in the past, pastor in a church, or someone, again, that you volunteer with, that can say they know you now and they can see the change that's happened in your life.
It sounds like it can get very exciting in court.
It can sometimes, although one of the goals is to try to keep it from being as exciting as possible by making it so that the judge feels like the evidence is overwhelmingly in your favor and they'll be more likely to grant it. So in some ways, the more of that kind of stuff that you can get together and have ready to go when you go into court, the better off you'll be. But that is one of the advantages of the new system, where you find out about the objection in writing in advance, is that it gives you time to get that stuff together, and it keeps you from having to get it together when you might not need it.
I think that's critically important. What other type of advice would you give to someone who's considering they did something stupid when they were young? Mm-hmm. What advice would you, number one, don't do anything stupid.
Right.
But what other advice could you give them?
I would say if you're considering getting an expungement or sealing done, it's probably better to get in touch with someone sooner than later. That way you can just know what the options are and, find out if there's a waiting period or not, find out if you have any ineligible cases or not. And it's better to know that sooner, even if it's something where you're not going to do anything right away, rather than leave it out there in the background. Especially now with this new law, because so many more cases are eligible to be sealed than used to be. It could easily be the case that someone 2 years ago told you can't do anything about this, and they were probably right then, but now it's going to be different, so you should get in touch and just find out.
Would it be helpful if someone was enrolled in school and trying to basically seek a different way of doing things?
That is. So there's two parts to that. In general, that is a useful thing to have. It's just a character reference type thing I mentioned. But also there's a specific new part of the law that if you complete either a high school diploma or equivalency or some sort of job certification training, either during your period of the sentence, like probation, or in the parole period afterwards, that will allow you to waive the normal waiting period for 3 years before you can file for a sealing. So if you complete, say, a job training or a GED while you're doing your probation, all of a sudden you don't have to wait 3 years. So that can be a very helpful thing too.
Wow, that's great. That's great. Well, I want to thank you very much for coming on the show and giving such important information. I think everyone should remember they have until the end of the year. And we hope that we can put this on our website so people will get the message. And you have until the end of the year if you're getting divorced, if you want alimony to be deducted from your taxes. So there are a lot of deadlines coming up, and if you need assistance, again, please call 773-731-1762, 773-731-1762, Monday through Friday, 9 to 5. Chicago Legal Clinic is happy to try to help. Thank you so much. Thank you, Drew.
Thanks again for having me.
And have wonderful holidays, everyone.